preservation of and increased access to the 92nd Street Y Humanities Audio Archives is generously funded by the National Endowment for the Humanities.
Good evening, and welcome to our debate on pornography and hate speech. My name is Susan Engel, and I direct the Adult Division in the Center for Adult Life and Learning. And thank you all for coming out on this cold winter night. Before I introduce tonight's program, I want to inform you of some upcoming events in this spring's About Women series. On April 4th, Carol Munter and Jane Hirschman, the authors of Overcoming Overeating, a Non-Diet Approach, will discuss their new book, When Women Stop Hating Their Bodies. And on Mother's Day, on May 14th, we will present a panel of prominent mothers and daughters, including Mary Catherine Bateson, who's also the daughter of Margaret Mead and Gregory Bateson, and the comedian Joy Behar, and the actress Blythe Danner, and their respective daughters will talk about their experiences, both being daughters as well as parenting in this day and age. I encourage you to buy tickets in advance to ensure your admission. And now for tonight. The format will be a debate, followed by a moderated question and answer period, and we've set up microphones in the audience and encourage your comments and your questions. As you know, our speakers are highly regarded lawyers, writers, and professors of law, and are probably two of the most eloquent and articulate spokespeople for their positions. So we are certainly in for a lively and enlightening program. Afterwards, we invite you to join us in the adjacent art gallery for a book selling and signing of Nadine Strossen's recent book, In Defense of Pornography, and an opportunity to discuss this issue further with both of our guests. It's now my pleasure to introduce our moderator, who will then introduce our guests. One of our guests, by the way, has flown in all the way from Calgary to be with us this evening. Leonard Lopate is the host of WNYC's New York and Company, which can be heard each weekday, and he interviews leaders in the arts, politics, science, and general culture for 2 hours of live, uninterrupted, spontaneous talk. New York and Company can be heard on WNYC AM from 12 to 2 p.m. Some of his guests have been E.L. Doctorow, David McCullough, Doris Kearns Goodwin, Francis Ford Coppola, Norman Mailer, Nadine Gordimer, Joyce Carol Oates, Anna Quinlan, and the list keeps growing. He has interviewed nearly every major political and literary figure there is. We welcome him to the 92nd Street Y. Ladies and gentlemen, Mr. Leonard Lopate.
Pornography is an issue that is as polarizing as any in our society, and there's been a continual legal battle over it as the result of a number of Supreme Court decisions in the late 1960s. Just this last November, the New York City Planning Board issued a report that concluded sex-related establishments have a negative impact on a neighborhood's character, economic development, and overall quality of life, and as a result, last month, one of the so-called adult video stores in the Times Square area was closed down as being in violation of a one-year moratorium designed to curtail the growth of sex shops. The matter, as is usual in these cases, is expected to go to the courts. Both of tonight's debaters have won court victories on the pornography front. Kathleen Mahoney, a professor of law at the University of Calgary, was a winning counsel in a case she pleaded before the Supreme Court of Canada that has established new and tighter pornography guidelines in her country. And Nadine Strossen is a law professor at New York Law School who, as president of the American Civil Liberties Union, has fought successfully against the application of similar guidelines in this country. Defending Pornography, Free Speech, Sex, and the Fight for Women's Rights is the title of her recent book. Each panelist will have 15 minutes or so to present opening remarks. Then they'll have a short rebuttal time, and then I will moderate a discussion. We'll end with a half hour of questions from members of the audience, and we will begin with Kathleen Mahoney.
Well, thank you very much. Thank you to the Y for the honor of addressing you folks here tonight on this very controversial subject of enormous significance for both our countries. Being here in New York is a little bit of a daunting experience for me, particularly on this topic. 3 weeks ago, your President Clinton visited us in Canada. I think our Prime Minister, Mr. Jean Chrétien, expressed similar sentiments to those that I am feeling when he described the Canada-US relationship in his welcoming remarks to Mr. Clinton at a special joint session of Parliament. What he said was, "Americans are our best friends, whether we like it or not." In the context of this debate, the issue of friendship and mutual respect is an important one. Virtually all pornography in Canada comes across the border from the United States. Our Supreme Court has found certain forms of this pornography to be criminally obscene because they harm Canadian women and children and the broader Canadian society. At the same time, influential voices, such as the ACLU, are claiming that the same material is not harmful and that regulations are not justified. Thus, the issue before us today seriously engages both sides of the border, and it centers on the issue of harm. Now, I'm going to tell you right now what I'm going to use my rebuttal time for. I'm going to use it to address several serious errors and misrepresentations of Canadian law that appear in Nadine Strossen's book. This is because the errors that have been made and repeated in the American mass media are not only unfair to us, they are unfair to you. Now, going to the first part of the debate. My first point is the test for harm must be objective and must consider all the evidence. Nadine Strossen says pornography is not harmful. She says it hasn't harmed her. It hasn't harmed a lot of her friends and colleagues either. She's quoted in the New York Magazine of January 16th of this year saying that she loves pornography. She likes to watch it in hotels when she's on the road, and I assume they're safe and secure 5-star hotels. And she loves watching the live sex at Show World in Times Square here in New York City. This is the place that features sexual intercourse on stage and rents out masturbation booths and so on. It also sells videos, and I'm just going, one of my researchers very kindly picked one up at that place that are advertised as follows: "Not for the squeamish. Watch as women are taken against their will, violated sexually again and again, and thrown into the street like yesterday's garbage." Ms. Strossen says she personally benefits from pornography because it allows her to reach new depths of her imagination. But what she didn't comment about in that interview was the darker side of pornography. The likelihood that most of those sex trade workers she was observing are drug dependent, that they experience a high degree of violence in their lives, including rape, beatings, and other forms of abuse, that more than 70% of them, the studies tell us, were likely sexually abused as children, and that as a group they suffer a homicide rate at least 40 times the national average. And also that a disproportionate number of them at Show World and places like it are women of color, many of them from countries like Thailand and the Philippines, where sex slavery, child prostitution, and the coerced trade in women and girls for sex tourism, pornography, and bride selling runs rampant. Then there are the disturbing testimonies of women and girls that speak to how they have been physically hurt by pornography in a multitude of ways. They don't enjoy it at all. The simple point I am making here is that any fair evaluation of pornography cannot be made solely from the consumer's point of view. That would be like leaving the fox to guard the chicken coop. Other interests must also be considered, the interest of those consumed. and those who are assaulted and abused and injured and sometimes even killed because of its use, as well as, I would suggest, the interests of women generally and the society generally. When a complete objective evaluation is undertaken, the need for a balanced approach becomes obvious. Now, the Supreme Court of Canada, in finding that some forms of pornography are harmful, looked at all the available evidence. Evidence of special committees, commissions, and task forces from Canada, the US, England, South Africa, Singapore, Australia, and New Zealand. It looked at transcripts of a variety of public hearings, including victim testimony, accounts of police personnel, sex offenders, clinical workers who treat sex offenders, rape crises workers, prostitutes, lawyers, and other expert scholars. The court found the power of the evidence came from its overwhelming agreement, regardless of source, that pornography causes serious harm, physical, emotional, psychological, and social, and it mostly harms women. Judge Easterbrook of your Seventh Circuit Court of Appeal also objectively looked at all the evidence. And he describes the more generalized harm to women in his decision in the Hudnut case. He says, pornography affects thoughts. Men who see women depicted as subordinate are more likely to treat them so. Pornography is an aspect of dominance. It does not persuade people so much as to change them. It works by socializing, by establishing the expected and the permissible. In this view, he says, pornography is not an idea. Pornography is the injury. At the international level, pornography is finally being seen as part and parcel of a much larger traffic in women. Last month, I attended an important conference at the Council of Europe in Strasbourg, where there is now wide agreement among the 33 member states that linkages between prostitution, pornography, child pornography, sex tourism, and sex slavery indeed exist, and the serious and odious obstacles they create for women's equality and ability to participate in public life must be addressed. In addition to the grave violations of human rights, to the women and girls trapped and coerced into this trade, the Council, the European Council, attributes the globalization of health risks related to AIDS and other transmissible diseases largely to this operation. Professor Radhika Kumaswamy, the United Nations Special Rapporteur on Violence Against Women, is of the same view. In her interim report of January 1995, prepared after studying pornography from all parts of the world, she states, pornography is not harmless fantasy. She says it is a form of violence. She concludes in her report that it is necessary for countries of the world to legislate against the violent subordination of women in pornography. And I can tell you of a case I am currently involved in Canada, that makes this point very well. It is a case of a double murder of 2 teenage girls who were kidnapped and tortured and raped for several days before they were ultimately murdered. Their assailant videotaped it all. And guess who now wants the videotapes? The press. Why? To exercise their freedom of expression. In light of the overwhelming, uncontradicted evidence of harm, the question shouldn't be whether pornography is harmful, but rather how much harm will women and children have to bear before steps are taken to protect them. Finding the point at which the speech of pornographers must give way to respect the rights of others to be free from harm is the challenge. This whole debate begs the question, how can something be experienced by one person as freedom at the same time as experienced by another as violence, oppression, or some other variant of non-freedom? Judge Easterbrook decided that women in the United States must pay the price for the free speech of pornographers. In Canada, our courts have gone the other way. They have held that the price of harming women, children, and minority groups through hate speech and pornography is just simply too high. Through all of this, though, Nadine Strossen and the ACLU still maintain that pornography causes no harm. Why? What is at stake? What is their stake, I should say, in putting women and children at such risk? I don't have the complete answer, but a clue can be found in the linear, decontextualized, and abstract analysis they use to justify their position. It is a fatally flawed analysis, It leads to an extreme First Amendment absolutism that cannot draw lines, not at child pornography, not at pornography made by actually assaulting women, not at sexual harassment through pornography, and I suspect not even at snuff pornography, as long as, of course, it is on film. Because time does not permit me tonight a full critique, I will examine 4 aspects of the ACLU argument explaining why it cannot address harm. Step 1 in their flawed analysis starts with a holistic approach to so-called sexual expression. All forms of sexual speech are lumped together in one big category. Now, this may be a clever debating strategy if the objective is to win a debate, but it's not a good strategy for getting at the harm of pornography or for creating sound policy to deal with it. For one thing, it creates false equivalencies between different types of speech dealing with sex. Birth control information, works of art, and books like The Joy of Sex are discussed in the same breath as violent sex and child pornography. Freedom of expression is associated with the preservation of the former, which forces an analogy to be drawn with the latter. The concerned citizen is tempted to end his or her thinking with a grateful genuflection to the freedom of speech principle, seeing it as an essential tool to preserve important freedom from state controls. Dumping all forms of sexual speech into one bucket circumvents the difficult intellectual and legal problem of balancing competing rights. It diverts the legal analysis away from the social meaning of what is being done by pornography and forces a constitutional defense of it on neutral ground. This, in turn, reduces society's responsibility for the result and protects freedom of expression as a process without a public context or an egalitarian dimension. It does not allow for any consideration as to whether or not free speech might have the result of diminishing, eradicating, or colliding with the freedoms of others. This does no justice, in my view, to either the integrity of the free speech principle or the right to equality. It muddies the waters of sexual expression by handily erasing the harm issue while giving legitimate forms of sexual expression a black eye. A more sound approach, in my view, is to differentiate between different forms of sexual expression, evaluating them separately. This reveals exactly what choices are on the table and what their social costs are. For example, any fair evaluation of sexually violent pornography, child pornography, and erotic pornography will lead to different results. Differentiating one from the other permits a principled approach, which can take competing rights into account. In Canada, we have embarked on an approach which goes some way towards addressing these concerns. In the case of Butler and the Queen, which was referred to by our moderator, the Supreme Court of Canada set out a method to differentiate one form of pornography from another. It said pornography falls into 3 categories, at least the pornography they're interested in regulating. First category is explicitly sexual material which is violent. Second, sexually explicit, degrading, and dehumanizing material which carries a substantial risk of harm. And third, explicit sex that employs children in its production. The court made it crystal clear that explicit sex without violence that is neither degrading nor dehumanizing is not obscene, and because artistic expression rests at the heart of freedom of expression, any doubt must always be resolved in the favor of art. Turning now to step 2 of the flawed ACLU analysis. Its wrong-headed insistence on empirical evidence of direct, linear harm. Now, Mike Tyson, I think, thinks the same way as the ACLU. In his statement at his sentencing hearing, Tyson said, "I didn't hurt nobody. Nobody has a black eye or broken ribs." His statement that I didn't hurt nobody, of course, was wrong. It expresses a common gender-biased misunderstanding about harm and the crime of rape. In his mind, rape only occurs if the victim suffers direct, visible injuries. He doesn't understand the victim's harm because he doesn't contextualize her experience. Denying the harm of pornography because it is not linear and individualized is a pornography consumer's concept of harm. The view that there is no harm in showing a video of a woman being raped and battered and subsequently saying she loved that confirms the deeply socially and pornographically constructed view of women's natural place, attributes, and just deserts as a sex object. How can you harm women by presenting them just as they are supposed to be? When Nadine Strossen says, as she repeatedly does in her book, that women against pornography are against sex, she is making a profoundly significant admission, an admission about what she thinks it means to be a woman. Which brings me to a third problem in Nadine Strossen's and the ACLU's analysis of harm. That is their use of deprecation of those who disagree with their position. She uses this technique against Kathleen Mahoney and Andrea Dworkin throughout her book. This dubious strategy depends first on convincing the reader that pornography is a relatively harmless form of expression. I think I have already demonstrated that she and the ACLU are on very shaky ground here. Once a person is tricked into believing there is no harm in pornography, the strategy is then to say those who oppose it must be intolerant and puritanical zealots, desiring to deprive men of innocent pleasure and women of their liberated sexuality. By deprecating those who are identifying the harm itself diminishes. A fourth flaw in the ACLU's analysis is their assumption that all women share the same values or experiences. This is evident when Strossen argues that some women enjoy working in the pornography trade. If they are consenting and happy, the argument goes, all women must surely consent to all the ways pornography is produced and used. Professor Ann Scales points out how this strategy was at work in the confirmation hearings for U.S. Supreme Court Justice Clarence Thomas. After being accused of sexually harassing Professor Anita Hill, he brought in other former female co-workers to testify that he never harassed them. Therefore, he could not have harassed Anita Hill. As Catherine McKinnon says, it was as if an accused bank robber brought in the testimony of officers of all the banks he didn't rob. The Butler decision in Canada went some way to overcome some of the analytical problems I have outlined. What was probably most remarkable about the decision was that it shifted the paradigm of 500 years of obscenity law from a mechanism to enforce morality to one of protecting women and children from the harm of pornography and protecting their equality rights. Obscenity law in Canada now measures the unlawfulness of sexual exploitation by the harm it inflicts or the risk of harm it creates. The court found that the purpose of avoiding harm is constitutionally valid when balanced against freedom of expression. A key legal principle underlying Canadian constitutional interpretation is its contextual approach. Canadian courts view rules, interpretive competitions, and people in their real-life circumstances. Thus, pornography is assessed in the context of a sexist and violent society that nevertheless has equality as a fundamental constitutional guarantee. Our constitutional equality law rejects the formal, empty, liberal approach to equality most countries, including the United States, use. Equality law in Canada is purposive. Discrimination is an effects-based assessment rather than an intention-driven one. The Supreme Court of Canada abandoned the Aristotelian approach of similar situation, saying it is so lacking in principle it could justify Hitler's Nuremberg laws. Instead, discrimination is decided upon a finding of inequality based on harm, prejudice, or disadvantage. Butler was informed by this thinking, as were the decisions which struck down abortion laws and reconfigured the law of self-defense to allow for preemptive strikes by women who fear imminent death from their aggressors. In other words, they did away with the barroom brawl model that underlies the traditional self-defense approach. Similarly, our new rape law, which shifts the burden of proving consent to the accused, finally gives rape victims a shot at equal protection because of this equality approach. The effects-based principle is also responsibility for the ruling that discrimination on the basis of pregnancy is indeed discrimination on the basis of sex. So in other words, Butler does not stand alone. It is a golden thread in a whole cloth of equality jurisprudence woven since the Canadian Charter of Rights and Freedoms came into effect 10 years ago. I will summarize now the points that I have made. First, pornography is harmful. The evidence is overwhelming and uncontradicted. Second, Nadine Strossen, the ACLU's position, is fatally flawed because it is based on an analysis which blinds itself to harm and thus is unprincipled and invalid. Third, what is required is a contextual approach to pornography which categorizes the different forms it takes. A fair evaluation of the harm inevitably leads to the conclusion that a balancing of rights must take place. Thank you for your attention.
And now Nadine Strossen.
Good evening. I'd like to thank the 92nd Street Y for arranging this debate, and I would like to publicly thank Kathleen Mahoney, as I did privately, for agreeing to debate me. Kathleen, that's probably the nicest thing I'm going to say about you. In seriousness, though, many advocates of restricting hate speech and pornography refuse to debate at least females or members of racial minorities who disagree with their positions. And I think that feeds into the substantive argument that underlies the advocacy of restricting hate speech and pornography, namely, and you heard Kathleen make this argument, that there is some inconsistency between, on the one hand, freedom of speech, at least as far as hate speech and pornography are concerned, and on the other hand, equality. In fact, nothing could be further from the truth, and that, and not what you heard from Kathleen, is the gist of my book, and it is also the gist of the ACLU's longstanding opposition to censoring either hate speech or pornography. That opposition stems not only from our deep devotion to freedom of speech, and I have to add that on those issues, the ACLU position is indistinguishable from the position of the United States Supreme Court. And I mean not only former Justice Brennan, but also present Justice Antonin Scalia, hardly a card-carrying member of the ACLU. And yet Scalia was the author of the most recent opinion on point, a unanimous opinion in a case from St. Paul, Minnesota, upholding the principle that what he called the bedrock principle of our free speech jurisprudence, namely that government may never censor expression merely because it is considered deeply offensive, disagreeable, even repugnant to the majority of the community on the basis of its content. And that is why hate speech and pornography, as defined by Kathleen and her colleagues in this country as a form of hate speech, namely sexually explicit speech that is degrading or dehumanizing or subordinating, because of that viewpoint neutrality principle unanimously endorsed by the United States Supreme Court and not just by the ACLU, that is why those laws are now unconstitutional in the United States. However, the ACLU has always based its opposition to those laws not only on our staunch defense of that classic bedrock free speech principle, but also on our deep devotion to and commitment to equality, gender equality and racial equality. Let me say that it's now the exact 75th anniversary of the ACLU. Since you've heard rather distorted things about the organization from Kathleen, I'll take this opportunity to tell you some of the true facts which are reflected in our organization's defense of pornography and hate speech. 75 years ago, when the ACLU was founded, our earliest clients included women such as Margaret Sanger, Emma Goldman, Mary Ware Dennett, one of our own founding mothers, who were repeatedly prosecuted, persecuted, harassed, convicted, even served time in prison. And why? Because their speech in favor of birth control, giving information to women that would help them to control their reproduction, their health, their very lives, that information was condemned as obscenity, was successfully prosecuted under anti-obscenity laws. Now, Kathleen tells me that I make a mistake and the ACLU makes a mistake when we lump together all sexual expression. The problem is that she and I may be able to tell the difference between birth control information that we think should be supported and other sexual expression that we may choose not to look at ourselves. But those who enforce the law, those who make the law, do not make those distinctions. And as my book shows, throughout history, under American law, under Canadian law, whether the epithet of choice happens to be pornography, happens to be obscenity, and yes, in some cases happens to be sexual harassment, what is systematically targeted over and over and over again is expression, ideas, words, pictures that is particularly important to women and advocates of women's rights, advocates of other minority group rights. I think it's strange that Kathleen would say that the ACLU takes and I take a very abstract approach to this issue, very linear, very intellectualized. I didn't hear her talking one word about the actual consequences of giving to the government, or to that matter, to our fellow or sister citizens, power to suppress sexual expression. She said she was going to reserve for rebuttal discussion about what had happened in Canada. Well, let me start to tell you what has happened in Canada. And yes, I have relied on American mass media. I have also relied on Canadian mass media. I have also relied on direct information from women and men, artists, writers, bookstore owners, and other activists in Canada, one of whom worked with Kathleen herself on the Butler case, and they say over and over and over again that this supposedly pro-feminist concept of pornography, one that supposedly will advance women's safety, will advance women's equality, in fact has had exactly the opposite impact. And it seems to me it shouldn't be surprising. After all, what we are doing is handing over to government authorities the power to suppress sexual expression that they deem to be degrading and dehumanizing. Should we be surprised, given the homophobia, given the heterosexism, given the very sexism and patriarchal institutions that Kathleen herself denounces, should we be surprised that the enforcing authorities in those systems would use this new subjective discretionary tool to suppress expression that is particularly important to lesbians and gays, to women and to feminists? I don't think we should be surprised at all. I think that result is predictable from the very analysis that Kathleen and her allies make. So let's get concrete about it. I said that one of her allies to whom I referred is a woman named Karen Busby, who is a law professor in Canada, who worked with Kathleen's organization on the brief in the Butler case. Busby herself said, and these are her words, they're so dramatic I can't forget them, "No sooner was the ink dry on the Butler decision than the police immediately raided a lesbian and gay bookstore in Toronto." And that was the first arrest and the first prosecution under this supposedly pro-feminist law. No sooner was the ink dry. And that prosecution was against Bad Attitude, a lesbian erotic magazine. And what was it for? It was for a story. The prosecution and the conviction were based on words, not on pictures. A story written by an American feminist lesbian writer, Trish Thomas, that describes a sexual encounter between two women. One of them initially does not consent, but ultimately becomes a consensual sexual encounter. Should we be surprised, nonetheless, when the male judge, heterosexual judge, says, "I consider this still to be degrading and dehumanizing," and the fact that there was consent involved made it even more degrading and dehumanizing? Unfortunately, given the homophobia on both sides of the border, we shouldn't be surprised that not only that judge, but others who enforce the law have said they consider all homosexual expressions to be inherently degrading and dehumanizing. Also very hard hit, and my source for this is not the American mass media, but a publication called Feminist Bookstore News, a Canadian publication, hardly mass media, given that there aren't that many feminist bookstores in Canada. The last news I had from that publication, which was quite a few months ago, so I'm sure the news is even sadder now, but as of a few months ago, they reported that well over half of all women's bookstores in Canada had their materials suppressed under the supposedly pro-feminist standard in the Butler decision. And I know that many of you have read about this, and it's documented on both sides of the border, that among the first works seized at the Canadian border under this supposedly new, supposedly pro-feminist concept of pornography were two books by the leading American anti-pornography crusader, Andrea Dworkin herself. So I think if we look at the concrete results, not only of the Canadian attempt to suppress sexual expression, but of all such attempts throughout history, it is not surprising that I conclude, as do other leading feminists in this country, such as Betty Friedan, whom I consider the founding mother of modern feminism, the New York chapter of the National Organization for Women, the California chapter of the National Organization for Women, many individual women who have devoted our lives to women's equality, women's safety, women's dignity, have concluded that more harm than good is done to those vitally important causes by giving the government power to go after sexual expression. We know that power is going to be used against us, and the Canadian experience simply proves the truth of that conclusion. Now, there are, Kathleen says that there are errors in the American mass media. I agree. One such piece that was fraught by errors, interestingly, was one that she quoted that appeared in New York Magazine, which purported to be about me, but I didn't recognize myself in it. But that's beside the point. My own tastes are completely beside the point, are not mentioned in my book for a very deliberate reason. I believe, and the ACLU's position, is to defend all expression regardless of our personal opinions about its worth or lack of worth. Our position, and my position in the book, is that individual adults should have the freedom to choose what to read, what to see, and correspondingly, what not to read, what not to see. I am no expert in pornography. I do not hold a candle to the expertise of Catherine McKinnon, who begins her lectures by bragging to the audience that she's seen more pornography than they have. I do not hold a candle to the Mies Pornography Commission. The reason why my book quotes some women who have seen a lot of pornography, who have performed for pornography, is to rebut the generalizations that are made on the other side. The generalization is that no women like pornography, no women see any redeeming value in it, and the women who perform for it are universally oppressed. Now, that brings me to the subject of harm, which was a major focus of Kathleen's remarks. And as she was talking about the harm that's caused by pornography, I wrote down a lot of the words. She talked about physical harm, assault, abuse, injury, trafficked, slavery, even killed, coerced, violent subordination. Those are all acts that are illegal, that are criminal, that are subject to civil remedies as well as criminal remedies, and it is completely consistent with my position that all of those actual harms caused by actual men to actual women are redressable and should be vigorously prosecuted to the full extent of the law. What does that have to do with images on the printed page? The point of my book, when I talk about women who voluntarily perform for the porn industry, is to say, yes, some women are certainly abused in this industry. I'm willing to take that on faith because I know that some women and some men are abused in every business. It does not follow, however, that no woman can freely, voluntarily, meaningfully consent to perform for pornography. And I show that by quoting voices of women who have made those choices. Moreover, if we are going to, and I certainly want to, protect sex workers from every form of abuse and exploitation, just the way I and the ACLU, through our Task Force on Workers' Rights, want to protect every worker in every business from every form of abuse and exploitation. It is counterproductive, however, to make their business illegal. If we make it illegal, we know it's still going to go on. We can just look to prostitution, drugs, many other examples make that clear. And once it is driven underground, it becomes, at the very least, extraordinarily difficult, if not outright impossible, to provide protection to those people who are still going to be making their livings in that business. So let's put to the side all of the issues about actual harm to actual people. I oppose those, and they do not have anything to do with images on the printed page that did not result from actual abuse of real people. Let's also put to the side this another red herring that Kathleen brought up, and that is of children and child pornography. My book contains not one word about that, and my position is, other than to say that I'm only talking about rights of mature, consenting adults. What I do object to is the false equation that is made by those on the other side between women and children. The model anti-pornography law that was adopted, that was proposed by Andrea Dworkin and Catherine McKinnon, actually equates women with children in being incapable of giving consent, even to signing an enforceable contract to pose for pornography. That, to me, is subordinating to women and hardly a step forward for gender equality. Now, in terms of the other kind of harm that is said to be inevitably associated with pornography, it is that supposedly when one looks at it, or at least in massive quantities, unless that is one is on the Mies Commission or an anti-pornography feminist, but the others who look at it are said to be inevitably driven to commit crimes and to discriminate against women. There is no evidence of that kind of causal connection. Indeed, the Canadian Supreme Court, in the Butler decision itself, recognized that there is no such evidence of any such causal connection. And they followed the direction that Kathleen was trying to lead you when she attacked the ACLU and, by implication, the United States Supreme Court for insisting that there must be empirical evidence of a direct causal connection between exposure to expression and harm, if indeed that expression is going to be allowed to be suppressed. That is true. That is the appropriately speech protective standard that the United States Supreme Court has insisted on. And that is one of the reasons why, by the way, Judge Frank Easterbrook, who was unanimously, or who was summarily affirmed by the United States Supreme Court without even hearing oral arguments or receiving written briefs, that is why he struck down the model anti-pornography law written by McKinnon and Dworkin. Essentially, under our legal system, you may suppress speech if, but only if, you can show a clear and present danger of actual or imminent harm. Any more speculative causal connection would eviscerate freedom of speech, because we can say that any kind of speech might lead people to have bad attitudes, which might lead them to engage in bad conduct, which might be bad for society. It was exactly that kind of thinking that led to the suppression, for example, of teaching Marxist literature in university classes. During the McCarthy era, the Supreme Court said, well, you know, that might lead some people to disapprove of the capitalist system, which might lead them to join in a revolution to overthrow us, and that would be counter to our national security interests. If we are to go down that road of allowing that kind of speculative causal connection to harm, as the Canadian Supreme Court has done, then we won't have any freedom of speech. And in fact, I do want to make clear, the Canadian Supreme Court in the Butler case explicitly said there is no clear causal connection that exposure to pornography leads to harm against women. However, the Canadian Supreme Court said that kind of evidence is not necessary in our system. It suffices that Parliament reasonably believed that that expression could lead to that kind of harm. If we go down that path, then I tell you, certainly neither Kathleen nor I will be allowed to speak here, and probably most of the people that Leonard Lopate interviews would also not be allowed to speak, because who can, the majority of our government might very well be persuaded that there could be some harm ultimately resulting from that speech. Well, I'm going to come to an end, although I assure you I haven't been able to respond to. I disagree with virtually everything Kathleen said. You'll have to read my book to find out why. And I'm going to end by quoting two folks. One is Max Allen, a Canadian producer with the Canadian Broadcasting Corporation. He said, "The difference between the United States and Canada can be summed up simply. We never fought Britain. The impulse to trust government runs as deep in Canada as the strains of rebellion run in the United States. You have life, liberty, and the pursuit of happiness. We have peace, order, and good government." And the last word I'll let go to Jamaica Kincaid, an African-American woman who opposes censoring both hate speech and pornography. And she certainly is a feminist and an anti-racist. And I'll let her have the last words. "Express everything you like. No word can hurt you. Not being able to express an idea or a word will hurt you much more as a bullet." Thank you.
And now we will have 5-minute rebuttals from each, and we're going to try to live by those 5 minutes. Those were 20-minute, 15-minute speeches.
As I told you, I'm going to use my rebuttal time to address the Canadian issue, because I do really think that's very important. However, Nadine has raised a number of issues, and I hope that they will come up in the question period, and I'll be able to have a chance to address them then. Now, Nadine Strossen claims in her book that the Butler decision has been used only to seize lesbian, gay, and feminist materials. She also claims that our experience in Canada since the decision has been an appalling one of nonstop censorship, and the adoption of the approach in Butler was as a result of the overpowering influence of Andrea Dworkin and Catherine McKinnon on the Supreme Court of Canada. She says the enforcement trend indicates that Butler is being used as a potent weapon to suppress equality rights of various disempowered groups, including the very women whose rights it was supposed to protect. Another claim she makes is that Canada's federal and state governments have passed laws to ban serial killer trading cards. I don't know where that comes from, but that's what she says. I will start with the last statement first. In Canada, we don't have states, we have provinces. Furthermore, we have a federal criminal code. No province can pass a criminal law because that would be unconstitutional. Finally, there is no law at any level, federal, provincial, or municipal, that addresses serial killer trading cards. Second, her claim that Catherine McKinnon and Andrea Dworkin are personally responsible for the Butler decision is laughable. It demonstrates a lack of knowledge or appreciation of Canadian human rights law, criminal law, and constitutional law, and the clear direction it has been taking for the last 25 years, far before Mr. Butler was ever charged, or for that matter, far before McKinnon's brilliant book, The Feminist Theory of the State, was ever published. While it is perfectly true that we benefited greatly by Catherine's analysis of equality and harm, it is an enormous exaggeration to suggest that the McDworkinite law, as Strossen disparagingly calls it, was put into place by the Supreme Court. Our criminal law of obscenity is entirely different than the McKinnon-Dworkin Ordinance. Ours is criminal, theirs is civil, ours is punitive, theirs is compensatory. Ours is a form of censorship, theirs is not. It is also interesting to note that in not one of the long line of Canadian decisions linking pornography and harm to women is there a reference or a citation to either McKinnon's or Dworkin's work. In fact, as counsel for the Women's Legal Education and Action Fund in the Butler case, I did contact Andrea Dworkin for her advice on the Butler strategy, and she advised us not to argue to uphold the legislation. We obviously did not follow her advice. Third, Strossen's claim that a wave of censorship against lesbian and gay pornography has engulfed my country is nothing short of ludicrous hyperbole. Since Butler, there has been one obscenity prosecution of homosexual pornography. One. There have been 12 obscenity prosecutions in total since 1992 in the entire country. Of the 12 prosecutions, 5 have resulted in convictions, 7 in acquittals. Of the 5 convictions, 3 involved material containing non-consensual, violent sexual assault, battering, and abuse of women by men. The one prosecution of homosexual pornography involved a photo text narrative, it just wasn't text, about a violent sexual assault between 2 women. The women were strangers. One was approached in a shower. She was pulled down, held down by her hair. Her breasts were clamped with metal clamps. She was raped, and at the end of the rape expressed enjoyment and asking for more. The 5th conviction involved a degrading and dehumanizing performance in a nightclub where women's faces were smacked with the erect penis of the male dancer. In the 7 cases which resulted in acquittals, more than half contained sexually explicit videos which included both heterosexual and homosexual, nonviolent sexual activity of all kinds. They were acquitted because the Butler criteria for obscenity were applied and they were not met. In light of these facts, I stress the word facts, I think any reasonable person would be hard-pressed to say the Butler decision has caused either a massive wave of censorship or mass persecution of the gay and lesbian community in Canada through the obscenity law. It is important for you to understand that prior to Butler, the morality test for obscenity almost always resulted in homosexual pornography being found obscene, regardless of whether its content was violent, nonviolent, or even about explicit sex at all. We are not pure from homophobia in my country. Since Butler, it appears that judges are reevaluating their views, and some have made the argument in the homosexual community that materials that are violent, because they are made for a different purpose for that community, do not have the same effects as heterosexual materials. Okay, I'll just conclude, thank you. However, that is still being discussed, and the homosexual community itself has not come to a conclusion. One final thing I want to say is that there is not one major women's group in Canada that is opposed to the Butler decision. For example, the National Action Committee on the Status of Women represents 640 groups in Canada composed of 3 million members, and their position is that Butler is a welcome new approach to obscenity, which allows a contextual approach to be taken, which looks at the actual reality of women in their lives and the effects violence has on them. Thank you.
All of the points that Kathleen said I made in my book, I didn't actually make, so I'm not going to bother to respond to them. They would have been beside the point. I'm not interested in who or why or how the law got into the shape it did in Canada. In fact, the heart of my book is exactly the opposite. I don't care who advocates censorship. I don't care what their motivations are. I don't care if they really, truly believe that the law is going to have some beneficial effect. My point is that every single such law, no matter how you label it, no matter how you define it, no matter who enforces it, inevitably turns over to the government and to other citizens decisions that can only belong to mature, consenting adults to make for ourselves. We have to choose what material we want to look at or not want to look at. And I think what's very interesting is what Kathleen did not respond to in terms of what has actually been done under the law in Butler. And I'm not even saying it's worse after Butler than it was before, although some of the anti-censorship groups and booksellers with whom I've been corresponding in Canada have made that point. They said that the obscenity law in Canada was falling into disuse and that Butler revived it. But I think the essence of the problem is summed up by what former United States Supreme Court Justice Potter Stewart said when he was struggling to define the hardcore pornography, to use his term, that should not be constitutionally protected in this country. He said, I cannot define it, but I know it when I see it. The problem is every single person sees a different it. That is why we always have to make those decisions for ourselves. Now, Kathleen did not respond to all of the information about the devastating impact on feminist bookstores, on lesbian and gay bookstores. Let me just quote, I've got many sources from Canada, but one is a news release that was issued, among other things, by LEAF, the organization for which she wrote the brief in the Butler case. In 1993, LEAF, together with a group of anti-censorship advocates, met to discuss how Butler was actually working. Yes, let's look at specifics. Let's not look at abstractions. And here is part of what that LEAF-endorsed news release says. Historic gathering condemns targeting of lesbian and gay materials and sex trade workers. Quote, since the Butler decision, Canada Customs, some police forces, and some government funders have exploited obscenity law to harass bookstores, artists, AIDS organizations, sex trade workers, and safe sex educators. Lesbian and gay materials have been particularly singled out. And that is not a statement, Kathleen, from the American mass media. Now, the same adverse effect has also followed, not surprisingly, from the anti-hate speech law that has also been upheld in Canada and also, I submit, has done as much harm to equality principles as it has to free speech principles. Let me tell you some of the examples that were cited by the 3 Canadian Supreme Court justices who agreed with the American position, not only the American Civil Liberties Union position, but the American Supreme Court position that these laws do more harm than good to equality values. Interestingly enough, that dissenting opinion was written by a female justice on the Canadian Supreme Court, Justice McLaughlin. She said, although the law is relatively new, it has already provoked many questionable actions on the part of the authorities. The record amply demonstrates that intemperate statements about identifiable groups, particularly if they represent an unpopular viewpoint, may attract state involvement or calls for police action. Novels, such as Leon Uris's pro-Zionist novel, The Hajj, face calls for banning. Other works, such as Salman Rushdie's Satanic Verses, are stopped at the border on the ground that they violate the law. Films are temporarily kept out, as happened to a film entitled Nelson Mandela, ordered by Ryerson Polytechnical Institute. Arrests are even made for distributing pamphlets containing the words, "Yankee, go home." Kathleen may applaud that result. And in one of the greatest ironies, and there are so many sadnesses when these laws are said to advance equality for racial minorities and for women, 1,500 copies of the book Black Looks, Race and Representations by the African-American feminist writer professor Bell Hooks were seized by Canadian customs authorities en route to Canadian universities. Ladies and gentlemen, I submit that in the misguided attempt to censor free speech in order to advance equality, Canadians have sacrificed equality as well as free speech. I hope that we do not follow our friends north of the border. Thank you.
I'll be throwing the whole thing to you in a few moments. There are microphones that are placed around the auditorium, and I hope you'll use them so that we won't have to repeat the question every time. But perhaps we can just clarify a few points before we get to that. The big issue about just what is pornography, Potter Stewart says it is. He knows it when he sees it. Ms. Mahoney, what's your definition? Is it Playboy or a photograph of a nude teenager by Sally Mann or Jock Sturgis, or is it something that has violence in it?
Well, pornography, the word, it seems to encompass all forms of sexually explicit speech. But my point is that you look at that and see what pornography is doing and what effects it has on the participants in it and on the general public. So what the court said, and I think they're right, is that pornography can be explicit sex. And they said that's okay. As much explicit sex as you want, that's okay. But pornography that we want to pay attention to in terms of legal regulation is pornography that employs children in its production, pornography which is violent and sexually explicit, and pornography, and this is the difficult one, which is degrading and dehumanizing, which carries with it a substantial risk of harm. Those are the three categories, and those I think are quite appropriate.
And Ms. Strossen, are there no limits as far as you're concerned?
The limits, Len, are the ones that I mentioned during my opening remarks. We cannot allow the actual abuse of any non-consenting, immature person. So children are off limits for use, and any exploitation of any person in the production is also off limits. But if we're talking about viewers and readers, then nothing is off limits.
Well, what about videos like Forced Entry?
What's that?
That was the video that...
I told you I'm not an expert on this stuff. What is it, Kathleen?
You were there,
no,
Nadine, I wasn't sure.
Kathleen held it up. It sounded rather horrifying. Do you have it in here?
I think it's in there, yeah.
Let me pass it over to you.
I mean, if you're talking about somebody not being actually abused, but the question is whether it says, not for the squeamish, watch as women are taken against their will, violated sexually again and again, and thrown into the street like yesterday's garbage. If people are, in fact, being raped, that is a crime.
Well, even if it's just
and if it's an enactment,
people's fantasies,
absolutely,
do we inure people to this sort of thing?
I would totally defend the right to see an enactment of a rape, and I mentioned one in my book that I think had very positive effects, and I will go personally on the record in terms of my reaction to this one, Kathleen. That was the movie The Accused, starring Jodie Foster, with a very brutal, horrifying, vivid, dramatic gang rape scene. I reacted to it, and the people with whom I discussed the movie reacted to it, not at all as an endorsement or a celebration or an encouragement of any form of sexual violence against women, but exactly the opposite, as a condemnation and a call to arms to our society to enforce the laws that make this kind of conduct illegal and to expand the laws as the ACLU has been working to do.
But the problem is, of course, this genre does not, in pornography, in the video pornography market, they do not show those kinds of rape that everybody is repelled by. What the predominant image is to have the person who is raped violently and against his or her will, at the end of it, express enjoyment for that kind of treatment, express enjoyment for suffering pain. And this is what our court meant when it said that the consent in and of itself can make it more degrading.
Well,
I mean, they weren't saying consent in the context
may I
that
respond
you
to that too? Again, you know, from something that I have seen and that I did describe in my book, which fits exactly into that definition. Lena Wertmüller's classic film, Swept Away, in a Beautiful Blue Sea in August, and it's got a much longer title. But as you will recall, that fits into this classic scenario. A woman who is raped and degraded and brutalized and humiliated falls in love with her tormentor, not just in lust, but in love with him. And I know many women who enjoyed that film, saw in it many feminist messages, saw anti-capitalist messages, artistic significance, political significance. How are you going to distinguish, or maybe you wouldn't distinguish, that kind of movie from some of the others you don't like?
The really thorny area here seems to be gay porn, because if pornography is a feminist issue, then how do we extend this to men having sex with men, women having consensual sex with women, whether there is faked rape or not involved? These are really to stimulate the fantasies of the people involved.
Well, first of all, a lot of the rape isn't faked, which is a problem in and of itself. And even if it's not, what it does is create a profit motive for people. Pornography creates the profit motive for people to harm other people.
Well, if it's for women for women or men for men.
Okay, well, let me get to that issue. And I think that's a very important one. And given that, and I don't back away from this for a moment in any way, that we have a society that's essentially anti-homosexual, just like you do. And we're working towards resolving those kinds of problems. What Nadine didn't say, and what's very important, and it's not in her book, that in September of 1994, the Butler case was cited to the customs authorities in terms of their guidelines, and they were forced to change them to allow explicit homosexual intercourse as being not something which was contrary to the standards of our obscenity law. So the Butler case was specifically used to allow that material now to come in, which prior to Butler, under the morality standard, was not. Similarly, the Butler case was used in the Little Sisters bookstore case, which Nadine went on about at great length, to support Little Sisters. Of course we supported that case. We were right there. My organization and all the women's organizations in Canada supported that lesbian bookstore against discriminatory law enforcement. I mean, power is not as stupid as it often looks. It shouldn't surprise anyone that with this shift in power that Butler represents, that you're going to get some public officials who will try their best to twist such a new approach to maintain the status quo. The reality is, this is now the law. The law is now beginning to work. After all, it was decided in '92. 500 years of law preceded that. We never expected everything to change overnight. Anybody that's here in this room that's in the legal profession knows full well that when a radical departure from the status quo comes about in law, it does take some time to catch. It's catching now. The customs regulations have been amended vis-a-vis homosexual sex, and what was previously thought to be degrading, which was anal intercourse, has now specifically been said to the customs officials, no, that's okay, because these people, that is their way of expressing their sexuality. Why should that be degrading and dehumanizing when we allow heterosexual explicit intercourse?
Is there anal intercourse heterosexually allowed, or is that...
Yes, it is. It doesn't matter what...
No, I meant in the films, because I heard about some films being... I'm not talking about what you do in your homes, folks.
Yeah. No, I mean, and this, I phoned the customs officials the other day, because I was quite concerned about the allegations in Nadine's book. So I spent an hour and a half on the telephone with them. And although we are very concerned about what appears to be focusing on gay and lesbian bookstores, what their comment is that we don't care whether it's heterosexual or homosexual. We apply what the government and the courts tell us to apply. And what they were applying before, they continued to apply post-Butler, but it wasn't a Butler-driven problem. It was a problem that existed forever. And in fact, the two cases which have challenged the customs legislation in this regard, the only two in Canadian history, both of them were started. One of them started 3 years before Butler in the courts. The other started 2 years before Butler. Again, Ms. Strossen does not point that out in her book. She leads the reader to believe that these cases were started after Butler. The reality is they weren't. They were in the system 3 years before. And now what we've got in Little Sisters is the opportunity to use Butler, which the lawyers did. They heavily relied on Butler to make the case for Little Sisters, to say, number one, the material that they have is not obscene on the Butler standard, and furthermore, number two, the law has been applied to them in the past, pre-Butler, in a discriminatory fashion because it has singled out homosexual material for differential treatment. So Butler clearly has advanced us towards a better place in terms of the way we officially treat our minority groups and special sexual minority groups.
Well, Kathleen, I wish that, part of me wishes that you were the person that was interpreting the Canadian Supreme Court decision, which you're not going to be, but I have some reservations about that too. It is absolutely true that finally the customs regulations have said that homosexual anal penetration will not automatically violate the Canadian standard. However, the standard, quote unquote, remains that inherently nebulous, vague, amorphous, subjective standard of degrading and dehumanizing. As a Canadian artist named Jacques Boivin, who's quoted in my book and to whom I recently spoke, says, "This just goes to show that the reputedly feminist definition is not a departure, but a further reformulation of paternalistic control. Same old baloney with a recycled label." I mean, you give to government officials the power to decide what is degrading and what is dehumanizing, and I submit that a whole lot of valuable sexual expression, especially in the homosexual community, is going to be endangered. Still reading from my book, according to the Toronto Star, books dealing with homosexual activities are seized regularly and often held for months, quite literally in an attempt to close down the offending stores. Notes Bruce Walsh, a spokesperson for the Canadian organization Censor Stop, quote, "Every gay bookseller in this country has attempted to sell their bookstores, but nobody wants to buy them." Close quote. Certainly, if I were with the Canadian Civil Liberties Association rather than the American Civil Liberties Union, I would argue, as they have argued in the Butler case, that that is a standard that should support my clients' cause. Every good advocate will do that. Unfortunately, it's not the Canadian Civil Liberties Association that is actually enforcing Butler. It is the police, it is the prosecutors, it is the judges, and nothing has changed.
Let me ask what may be a naive question, but in discussing this, are we talking about a Canada that has a free speech provision in its constitution? Are we, in a way, almost doing apples and oranges here?
Yes, of course.
I mean, because we're applying
provision.
Canada to the United States, and we do have very different constitutions, don't we?
Well, it's not all that different. We didn't get a constitution until 10 years ago. We had what we call an implied Bill of Rights, much like Great Britain still does to this day. In 1985, we developed a Charter of Rights and Freedoms in a different context than yours, a context where women had the vote, where we didn't have slavery, where minority groups had a voice. People were going to law schools, that rights are affected by the Charter. So our Charter is rather unique in the sense that we have what you wanted, you women wanted at least, and I'm sure some men, the ERA, but we have it in a very powerful way in our Charter. We also have a provision that says, notwithstanding anything in this Charter, women and men must share rights equally. We also have a Section 1, which you don't have expressly in your Bill of Rights, a Section 1 which expressly says that in a context of a free and democratic society, rights may be limited if they can be justifiably shown that they need to be limited to preserve the democratic ideal of the country. So in other words, limitations can happen, but they must be done in the context of other rights, in this overall view of the democracy that we live in. So this is why I made the point in my remarks about balancing rights, about contextual approach, seeing rights in the real world, in how people experience them as they experience their lives. So that when women, for example, and children experience as a social problem in Canada, violence in the home, sexual abuse, rape, sexual harassment at work, we must interpret rights and issues in the context of that social problem when we're looking at the notion of rights and the balancing of rights. So that is, it's not unique, but I think what is unique is that it's being interpreted in a different way, in a different contextual way that I think has been responsible for a number of other cases, which I expressed to you very briefly, like the abortion issue, the pregnancy discrimination issue, the issue of the rape laws, etc., the issue of self-defense. The Charter rights are imbuing the whole law with this context that we must look at how the law affects people. And it affects often women differently than it affects men.
Now,
and to have a more perfect balance, we must take that into account.
We had implicit limits in our country until the 60s, didn't we? For most of our history, sexually explicit material was not allowed, and that still applies to radio and TV. I don't sense that any irreparable damage was done to the Constitution as a result for, 150 years or so?
In terms of freedom of speech, I really couldn't disagree with you more, Leonard, with all due respect. I gave one example during my opening remarks that dated as recently as 1961, when professors who were teaching Marxist literature, assigning that to their students in their classes, were criminally prosecuted under laws that suppress freedom of speech. That was 8 years before the court adopted its current, I think, correct interpretation of freedom of speech, that it's got to be protected unless you can show a clear and present danger of actual or imminent harm. And I want to make clear that it is that standard that would apply to the concept of pornography that Kathleen has successfully advocated in Canada, because that concept of pornography is a form of hate speech, namely sexually explicit, sexist speech. And so it is under the hate speech analogy that Judge Frank Easterbrook struck down those laws, and I think that's the correct decision. There's no doubt that the freedom of speech tradition in this country is much stronger than the freedom of speech tradition is in Canada. There's also no doubt, as I certainly know from the ACLU's ongoing work in this area, that gender equality is not nearly as protected in this country as it should be. We unsuccessfully struggled for the Equal Rights Amendment to the United States Constitution. We brought a series of lawsuits and are still bringing lawsuits to try to persuade the United States Supreme Court to recognize that gender equality violates the Constitution, or gender discrimination violates the Constitution to the same extent that race discrimination does. When we finally win, and I believe we will finally win, now that the the founding director of our Women's Rights Project is on the Supreme Court, namely Ruth Bader Ginsburg, when that day finally comes, we will have a second argument against censoring pornography, because I believe censoring pornography is as violative of true gender equality as it is of freedom of speech.
I want to go to the audience. This is the sort of discussion that could keep on going back and forth all night. Because of my own political prejudices, let's start with the left.
Thank you, Mr. Lopate. My question is for Professor Mahoney. Earlier in your talk, you made some reference to Nazi Germany and the Nuremberg laws, and that reminded me of a book I had read about the persecution of gays under the Nazis, written by a scholar named Richard Plant. The book was called The Pink Triangle, the Nazi War Campaign Against Homosexuals. And in his book, he says that on February 23rd, 1933, Nazi Germany passed a law against pornography. And on the same day, they also passed a law against gay rights organizations. And my question very simply is, on that issue, do you think the Nazis were right?
Oh, that's preposterous. I don't have to answer that, I don't think.
Well, thank you for your question.
May I just make a comment on it, not specifically on the question? I would object to guilt by association, but it is true, as I point out in my book, that all governments, including Nazi and communist and other totalitarian authoritarian regimes, have used the term and the concept pornography to ban not only sexual expression, but political dissent. Political ideas that they disagree with are labeled and tarred and suppressed as either pornographic or obscene.
Yes, it would seem to me that this movement extending pornography to the hate speech concept, as opposed to the old tendency to deprave and corrupt, is an extraordinarily dangerous phenomenon. It contradicts the principle of the Miller decision, in which something with literary merit, something having literary merit, was a defense against prosecution for obscenity. Here, the very opposite might be the case. An outstanding academic book, because of its effectiveness, will be far more dangerous than a trashy book picked up in a porn store.
Is there a question here?
Yeah, I'm just wondering, I'm asking Professor Mahoney how one would worry about the extension of this into the academic sphere, well beyond what we think of as pornography, into intellectual books which attack women or attack racial groups.
We didn't get enough time, obviously, to talk about a lot of the other aspects of our laws, but what I didn't say, and is important to answer your question, is that in addition to the characterization of pornography that I talked about, Canadian law also has a number of defenses. And in fact, in the Butler case itself, it talked about art. We also have art, literary merit. We also have scientific merit. We also have public good. All of those things are defenses to any allegation, in fact, that can be made out of pornography, but those defenses can be made. And in fact, we have never had in Canada any conviction of a academic literary work. The vast amount, at least to date, for the last, I would say, 10 years, if you look at the cases, have not in any way touched art or anything literary. Essentially, what the focus is on mainly video, but also some sort of magazines that promote violence and torture and things like that. So those defenses are there. Similarly, we have hate propaganda. I was not making those connections. Nadine was. In Canada, what we have is we have a law of obscenity that deals with what I was talking about. We also have a separate law for the public willful promotion of group hatred. I also happen to be, I'm the real bad one tonight, argued successfully in that case, which was the first hate propaganda case before the Supreme Court of Canada. We similarly argued a harms-based equality analysis for that. In that particular case, it involved a man who was teaching his students at school from grade 6 through to grade 10. It was that Jews were to be despised and to be exterminated and that the Holocaust never happened and so on and so forth. He was teaching that in his school. So there was no marketplace of ideas happening there. He graded them well if they did the hate propaganda nicely, and he graded them poorly if they in any way challenged his ideas. That was the factual basis of the case.
Would you defend that man?
He certainly should be fired from his position as being a school teacher, but he should not be criminally prosecuted under the law, as the 3 dissenters versus the 4 majority justices argued for among the reasons that I mentioned, that this law is a very dangerous tool that can be used to suppress important ideas. I want to make 2 points in response to what Kathleen said. Number one, there is an important distinction between the Canadian obscenity law and the anti-pornography law that's been proposed in this country by folks such as Dworkin and McKinnon, in that theirs would not, in our country, would not have an exception for material that has serious literary, artistic, political, or other value. In their view, if women are subjected, it doesn't matter, and now I'm paraphrasing Catherine McKinnon, it doesn't matter that the work has other value. So it would be even more dangerous to free speech than the Canadian approach. But the more important point I want to make is that it doesn't matter ultimately whether or not there is finally a conviction that is upheld on appeal. There is enormous adverse impact on freedom of speech, self-censorship, a chilling effect, a deterrent effect from having to defend against a prosecution or from having to avoid a possible prosecution. So we're being very naive and simplistic if we say we're only confining our evaluation of the sensorial harm of these laws to those prosecutions that ultimately are upheld on appeal.
Kathleen, I know you want to respond to the chilling effect aspect.
Well, there's been so many things said, it's really hard to pick things out. Like, for example, the chilling effect. Nadine puts a lot of stock in the word seizure, goods seized at the Canadian border. So I asked the customs officials, what does that word mean? And what they said was, their duty as customs officials, obviously I'm sure you would agree that any nation has the right to protect its borders from what they determine to be contraband or treasonous material or hate propaganda, whatever that may be. Every country has that sovereign right. What the customs officials do is they apply what they're told to apply. So they have to look for, randomly, if you go to any border point between our two countries, you will see thousands of vehicles, and many of them trucks, importing material into Canada. The way that customs officials work is that they must randomly select things from those vehicles bringing material into our country, whether that be agricultural products or whether it be products that are expressive products. And when they open a box, say, of books that they're looking for in terms of seeing whether or not they comply with the law that they're supposed to apply, and they see something that they're perhaps not sure of, what they do is they put it into a category of something that has to be checked. The vast majority, 99%, of these things are checked and they're put back into the stream. That may take a day, that may take sometimes 2 weeks. But she made the point that Andrea Dworkin's books were seized at the border, which is quite an ironic thing. But in fact, when I checked on that book was in a box of other books going to someplace that were looked at. It was 2 hours. Now, I don't think that's a big chill, frankly. I think that that's us applying our laws in a way in which we're perfectly entitled to do, and it's a perfectly responsible thing to do. I suppose the alternative is you just close your eyes and everything comes into our country that anybody wants to send there. Frankly, we do have standards that are somewhat different than yours. For example, even your pornography producers know that. Playboy does a Canadian edition. Penthouse does a Canadian edition. Hustler, etc. They know that our standards are different. What's wrong with that? Surely we're entitled to have our standards, because we think there's other competing rights that are important. Even the pornographers recognize that. Even they respect the fact that as a sovereign nation, we have a right to protect our borders from whatever the threat may be.
Let's go to another.
Unfortunately, even Oxford University Press has recognized this and refused to distribute in Canada some classic works of gay literature by serious writers, literary scholars, and historians, and especially those who engage in periodical publications have even given up sending many publications to Canada because a so-called temporary detention can in effect be permanent if by the time your magazine finally gets distributed, it's severely out of date. Many Canadian bookstores are reporting that if they are ever able to get their materials out of the hands of customs, sometimes they're damaged, sometimes they're destroyed, sometimes they're lost, quote unquote. It is true that if you have access to a lot of press and a lot of free speech, and ironically, despite her complaints to the contrary, Andrea Dworkin does have a lot of access to press and free speech. There was a hue and cry raised on her behalf when her books were seized, and therefore they were released relatively soon, although my sources say it was 2 days rather than 2 hours. The important point is that there is so much discretionary authority there, and the small presses and those especially, again, who are producing lesbian and gay material are not able to raise their voices, and they've just simply given up shipping into Canada altogether.
Let's take another question.
I know I'm sort of changing the subject a bit, but, and this really isn't a loaded question. I really am looking for an answer because I don't know this. In terms of First Amendment and free speech and the fact pornography is sort of covered under free speech, why is it that verbal sexual harassment is not just seen as First Amendment expression, not sort of a threat of there's going to be violence here, but just verbal expression? Why don't you see when men or women are being accused of this that they don't say, well, that's my First Amendment right, I can say what I want? And with the any legislation about that, do you find that unconstitutional?
That's a very good question, and I actually have a whole chapter in my book on sexual harassment because it's very complicated. I'll try to be as simple as I can. Obviously, words, or to me it's obvious that words can be used in a harassing fashion. Pornographic expression can be used in a harassing fashion, but one has to look at context as well as content. What I object to are distorted concepts of sexual harassment that automatically equate all sexual expression with sexual or sexist harassment or discrimination. Let me take 2 examples that come from an actual case. They involve a workplace where women have traditionally been excluded, a shipyard in Florida. In that case, a complaint was made that pornography was being used in a harassing fashion. I think some of the complaints were justified and some weren't. An example where that complaint was justified, in my view, was when the pornographic pictures were repeatedly shown to the women workers after they made clear that they objected to it and were offended by it and were embarrassed by it and were humiliated by it. When, under those circumstances, their co-workers continued to show them pornography and to laugh at them when they became visibly upset, that is using pornography in a sexually harassing fashion. To take another example, also from a case that the ACLU was involved in Los Angeles, there the fire department adopted a rule that said no firefighter could bring to the workplace in any context, at any time, under any circumstances, any sexually suggestive material. That meant that even on their downtime, when they're, after hours on call but not working in their little private cubicles, they would not be allowed to look at not only Playboy, but also Sports Illustrated, Our Bodies, Ourselves, you name it, all of that, and we can think of many more that are sexually suggestive. We argued that that violated not only freedom of speech, but privacy, and the judge agreed with us. So I think you have to look at the context and not the content alone.
Who determines the context? Is that the policymaker? Is that up to you? Or the
Initially,
ACLU?
it would be the policymaker. As the Supreme Court said when in its last decision on sexual harassment, which was unanimous, the court said you are going to have to look at all of the facts and circumstances to take into account the kinds of variables that I suggested. And initially, that should be done by the rule at the workplace, I think should spell out what some of the relevant factors are. If there's disagreement and dispute, ultimately, it's going to be the courts that have to decide.
Thank you.
Thank you.
Kathleen, do you want to get into this, or should we're fast running out of time.
I think we should hear from some of the
I
people
think
that are here.
we can get 1 or 2 more in.
Okay, Ms. Strossen, about 10 years ago, the Michigan State Police did an investigation of sex criminals, and they discovered that about 41% of them had copied their crimes from pornography. Did their report influence your position in any way?
I've heard about that report, and I'm sorry I don't have at my fingertips the response to it, because I know I did see a response by somebody who tried to track down the origin of the report and found out that it was really specious. It was not an official report. It came from some individual police officer, and it wasn't scientifically done. But putting that aside, let's assume for the sake of argument that 40% of sex offenders had looked at pornography. I think it's fair to say that 100% of them had drunk milk, and probably an extremely high percentage of them had read the Bible and gone to Sunday school and done other things, and we would not leap to the conclusion that because of those kinds of correlations that there's some kind of causal effect. In fact, I find it odd that police officers and others who advocate censoring pornography would repeatedly cite what I think are very self-serving declarations on the part of convicted criminals or accused sex criminals. Oh, it's not really my fault. Pornography made me do it. And as I show in my book, that, I think, is deeply damaging to the very important cause of women's safety if we allow the actual men who are actually raping them to displace their responsibility and their criminal culpability onto words and pictures.
Okay, thank you.
Kathleen, you want to add anything to that?
Well, I guess when I hear arguments like that Nadine has just made, what comes into my mind is a mental image of somebody with their head buried in the sand. Because you don't make false equivalencies like drinking milk and reading the Bible when we can see patterns of human behavior, as much as she doesn't want to admit it, but that are there, and any reasonable assessment of that would show a reasonable person that there's some risk of harm here. Of course, it's difficult to show a causal link between any stimuli and human behavior, because we are not automatons. The human brain is a very complicated thing. And so many things motivate us to do other things. However, it strikes me that to take such a doctrinaire position and to raise these false equivalencies, to try and divert our attention from things that go on in our society, that any reasonable person can see linkages with, is to me to close your eyes to reality, to close your eyes to the harm. Repeatedly, she avoids the question of harm. Why is it that we have had 25 years of research of all kinds, if you're at all familiar with the data? There's been 25 years of research and different conclusions and different methodologies, etc. But the interesting thing is they all go in the same direction. That is why Canada, New Zealand, Australia, the US Commission, all of these things have a thread of continuity, a thread, not more than a thread. I mean, the whole thrust of these reports is this is harmful. And that's after a careful, deliberative assessment of all the evidence. This is what we're not hearing with respect from my colleague. We're not hearing an assessment, an objective assessment of all the evidence. We just hear these strange comments being made which do not address the point. I would just like her to address the point. And I think that's really important. And I think that if she's prepared to concede that this is an important issue that engages all of us. I have 5 children. I'm concerned as much about my 2 daughters as my 3 sons. I also have a father and 2 brothers and people in my life who I love. And I don't think that this is helping them. I don't think it's helping me. And that's not from a puritanical point of view. That's not from a religious point of view. It's from a human rights point of view. And I think as responsible citizens, whether of the US or of Canada or any other country, we have to come to terms with the evidence. That's all I'm saying.
We're about 10 minutes past the appointed close of this thing, so whenever we end it, people are going to be unhappy. You want to say one more? You look like you have to say one more thing.
I'm dying to say 100 more things at least, but I'll confine myself. Self-censorship here. Just in terms of the alleged false equivalency, Kathleen, the Bible has in fact been blamed with great credibility by many people throughout history around the world for having instigated crimes of violence against children, against women, against men. Obviously, I would be naive if I said some people are not influenced by what they see and what they read. Of course they are. It's precisely that words are so powerful that I defend them so strongly. And we have to use words to oppose those that we disagree with. But if we allow ourselves as adults to be remitted to only seeing or reading material that is not going to drive some depraved person somewhere to commit some antisocial act, then I submit we're not going to have anything to see or read. And the first work to go is going to be the Bible. Not a minute too soon.
Unfortunately, we're going to end it here. I thank you very much for coming.
Thank you.
I thank you, Kathleen Mahoney, Nadine Strossen, and you will be in the back. They will be here signing books and talking to you, so enjoy.
Thanks for listening. For more information on the 92nd Street Y, New York, and all of our programs, please visit us at 92ny.org.